But the real crux of this matter is as to what is the legal effect of the said mutation entry number 2053 at Exhibit 45. Stop. The trial court has come to the conclusion that because of the said mutation entry, Sonatai Jyoti Gharge got title to the property in question along with other properties. Stop. But that finding of the trial court is not at all correct and proper. Stop. It is settled law that mutation entries or entries in the record of rights are made only for the fiscal purpose of recovering revenue. Stop. The said entries cannot amount to transfer of the title of the holder of the property in favor of the person in whose name the entries are made. Stop. Therefore, merely because Pali Pandurang Gharge, father of the present applicant number 1, happened to make a worthy application on 3rd of September 1956 to delete his name and to enter the name of Sonatai Jyoti Gharge, that act on his part would not amount to transfer of the property in question, and that giving of the worthy application and certification of the said mutation entry would not create any title in favor of Sonatai Jyoti Gharge. Stop. Therefore, merely because the name of Sonatai Jyoti Gharge is entered in the Kabjedar column of the record of rights on account of the mutation entry at Exhibit 45, it could not be said that in law Sonatai got title to the property in question. Para. With regard to second substantial question of law, that is, the co-owner cannot claim an order of injunction against another co-owner with regard to the property owned jointly. The learned counsel for the appellants had relied upon the apex court's judgment Muhammad Bakar and others versus Name un Nisa Bibi and others. Stop. The apex court has very categorically held in para number 7 as under semicolon para the parties to the action are co-sharers, and as under the law possession of one co-sharer is possession of all co-sharers. It cannot be adverse to them unless there is a denial of their right to their knowledge by the person in possession, and exclusion and ouster following thereon for the statutory period. Para. The learned counsel for the appellants also relied upon another judgment Patel Meghji Dayal and others versus Patel Jeevraj Pragji and others with regard to the second substantial question of law. Stop. In para number 2, this aspect has been considered as under colon, but the real crux of this matter is as to what is the legal effect of the trial court has come to the conclusion that because of the said mutation entry, Sonatai Jyoti Gharge got title to the property in question along with other properties. Full stop.